Did you know that when you bring a medical malpractice lawsuit in New York, there is a very good likelihood that when all discovery is complete, the defense lawyers are going to ask the judge to throw your case out without you ever getting a dime? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And now, when you bring a lawsuit for medical malpractice, we have an opportunity to question the witnesses who are involved. Likewise, the defense has an opportunity to question you, to learn from you what happened and what problems you have today. After all the discovery is complete, and now we tell the court that your case is ready for trial, we put your case on the trial calendar. But guess what? That now starts the clock ticking to give the defense an opportunity to try and kick your case out of court before it ever gets to trial. That's known legally as a motion for summary judgment. The defense wants your case kicked out before you ever get to trial. So now the attorneys go into court to argue each side of their respective positions. The judge in front of a packed courtroom full of attorneys waiting to be heard on their motions. Now the judge is going to listen to oral argument. The attorney who's making this request, the defense attorney, is going to tell the judge exactly why he believes that there's no valid case. And they're going to have a medical expert to confirm that there's no valid basis for a case. We, on the other hand, now have to reply and say, Judge, our medical expert confirms that there is a valid basis for a case. And Judge, we should be allowed to present this to the jury so the jury can determine which set of facts they believe. Is the judge going to make an instant snap decision right there after listening to oral argument? The answer is no, he's not. You want to know why? It's because the judge needs to review and fully evaluate both sides. He needs to evaluate the legal cases that are cited from each attorney. He needs to do legal research and have his law clerk help him do legal research to determine whether or not there truly are legal issues to be resolved or factual issues. And if there are only factual issues to be resolved, to determine who's more likely right than wrong, then in all likelihood the judge is going to say in a decision weeks or months later, defense attorney, there are questions of fact to be decided by a jury. Your request is denied. On the other hand, if he says, no, you've shown to me that you're entitled to a dismissal, the judge is going to say, yes, Mr. Defense Attorney, you're absolutely right, case dismissed. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on when you decide to bring a lawsuit for medical malpractice here in New York. You know, I understand you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you haven't done so yet, and you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.